I'd like to welcome you to today's webinar. I'm fortunate to have with us today two of my other partners, Stephen Penrod from our benefits group, and John Weimer, who will touch on some traditional labor issues toward the end of the presentation and of course weigh in on some of the larger issues as well. From now until 1 o'clock, we will share our presentation regarding employment and benefit issues that you might be dealing with as a result of the COVID-19 coronavirus. During the webinar, please feel free to use the question box typically located in the control panel to the right side of your screen to submit questions. After 1 o'clock and up until 1:30, we will take those questions and answer them to the best of our abilities. If we can't get to all the questions today during our time together, we will respond via email after the webinar. So with that, I would like to just give a brief overview of our agenda for today. There's a lot to cover. It's uncharted territory, which changes every day, often multiple times a day. Some answers to issues are not clear at this point, but we are here to help you navigate across a number of issues, including leave issues, disability issues, wage and hour, discrimination, traditional labor issues. We will touch on, just briefly, some immigration concerns as well. Of course, you all are probably painfully familiar with the basics at this point. The coronavirus, COVID-19, is now on every continent except Antarctica. By latest count, at least 36 states, because I know as of last night, Ohio joined the ranks of having a couple of cases in the Cuyahoga County area. And if you haven't begun your contingency planning yet, certainly when we finish here today, it's the time to start. In terms of the substantive issues, we're going to start with some employee benefits issues, and I'll turn it over to Stephen.
Great. Thank you, Debbie. So one area that we want to talk about is group health plan coverage. And so one problem with the length of time period for this coronavirus are the quarantines that we've all become intimately familiar with everything that's been in the press lately and everything that's been talked about. And so we'll talk later a little bit more about leaves of absence, but when employees aren't working, either due to a quarantine or some sort of a furlough, or let's say when you shut down a plant because of concerns over coronavirus, whenever you have that situation, one concern is eligibility for benefits, and in particular, group health plan coverage. And so if you have an employee who's no longer working, there is a concern that they may no longer be entitled to group health plan coverage after a period of time, especially if you're using the Affordable Care Act, hours of service coverage, they could potentially lose coverage fairly quickly. And so, one recommendation we have for our clients is, make sure you review your plan document, make sure you understand the requirements for active employees and what happens and how long an employee will maintain coverage after, while on a furlough or some sort of unpaid leave of absence. And then you'll want to consider possibly making some changes to your plan in order to credit hours of service for extended periods of time or extended absences due to the coronavirus. And so if employees are not working and they're unable to pay their share of the premiums due to being on an unpaid leave of absence or a furlough, again, one of the concerns is that is how are they going to pay for that coverage? And so the answer to that question really depends a lot on whether it's a paid or an unpaid leave of absence and whether it qualifies for FMLA. And so Debbie's going to talk here in a few minutes about FMLA coverage, but let's just assume for a minute that we have an unpaid, a non-FMLA leave. That could be a concern because oftentimes with a paid leave, whether it's FMLA or otherwise, you can continue to take premiums from the pay that you're paying the individuals. But if it's an unpaid leave of absence, the concern becomes, how are individuals going to continue to pay for that coverage, and what happens from there? And so, an employer may be able to take some sort of an action to allow coverage to continue. However, you have to be very careful with that because the FMLA rules provide that anything that you offer on an unpaid or on a non-FMLA leave of absence has to also be offered on an FMLA leave. And so you don't want to inadvertently, set a precedent where you're, providing some additional coverage for individuals on an unpaid non-FMLA leave of absence that you then have to turn around and offer to individuals on FMLA leave. And so obviously each situation requires an individual assessment. You want to make sure that you're checking the insurance policy if it's a fully insured product or your plan documents to make sure that, number one, you understand what the parameters are and what your limitations are, and then what you want to do going forward. But again, a couple of things to be concerned with is coverage for eligibility for plan coverage and paying for those premiums when on a coverage. The other concern is cost sharing and high deductible health plans. So a lot of employers and a lot of our clients are asking questions about offering free testing, doctor's visits, hospitalization related to the treatment for coronavirus. And in fact, the New York Department of Financial Services had a directive just last week for insurers, so fully insured products in New York State, that they waive the testing and, for when it's available, immunizations for the costs associated with the coronavirus. And Cigna just recently had an announcement that for their insured plans, they're waiving all cost sharing for the coronavirus testing. And that's, that's great. That's great that they're encouraging, their employees, their individuals, their members to get the testing, to get the immunizations when they come about, and are encouraging that, incentivizing that by providing that coverage. The problem you have to be concerned about is the high deductible health plan concern. So if you have an HSA compliant high deductible health plan, you cannot provide coverage to an individual until the minimum deductible is satisfied, unless it's for preventive care. And unfortunately, as of right now, services associated with the coronavirus do not fall under the preventive care exception. And so it's a concern that if you are providing this coverage without a cost-sharing component, not charging the employees, they may be ineligible to contribute to an HSA. Now, we certainly understand that it's possible that the IRS will take some sort of an action to allow participants to have these services paid for, without a penalty under the HSA rules. That's certainly a possibility given the seriousness of this disease. There's also a possibility, even without that guidance, that the IRS will take a non-enforcement position and say, we're not going to enforce these rules and make individuals ineligible for HSA contributions during the time these services are being paid for. And in fact, the state of New York and/or Cigna may have, we don't know that for a fact, but may have had some assurances from the IRS that their stances were, that there was going to be no enforcement action taken against them for those services. So they may be relying on that non-enforcement stance from the IRS. We just don't know. But again, something to be aware of, and possibly look for guidance from the IRS on, maybe some sort of loosening of the rules with regard to that. I'm going to turn it back over to Debbie.
Thanks, Stephen. As I mentioned at the outset, if you haven't done so already, it's really important that you develop a pandemic plan. And at this juncture, of course, neither the CDC nor the WHO has labeled this as a pandemic, but certainly the response we've been seeing is different than any other outbreak we've seen. Twitter and Amazon and other large companies have instituted work from home policies. We've seen business conferences canceled. Just last night, I heard that Ohio State is doing most of its face-to-face classes remotely until the end of March, and we're beginning to see school closures. So certainly you are going to see an uptick in absences even if there's not an outbreak. Maybe it's simply related to school closures and preventive issues. But it is important that you make a plan so that you can handle potential exposure in the workplace, so that you have protocols in place to protect your employees, avoid misinformation, monitor governmental guidances and requirements. And a critical first step in that plan is to designate a team and a senior level point person who can be responsible for monitoring updates, gathering that information, reporting back to upper level management, communicating with employees, issuing communications to employees, because it's really important that you keep your workforce informed. So that point person is very, very critical. Also critical is develop a checklist so that you can sit down and ensure that you have addressed as many issues as possible that you anticipate may come up in your workplace. The task force here within the Thompson-Hein Group has developed a checklist for employers that starts from the recruiting process and goes all the way through employment and benefit issues, including immigration. So if any of you are interested in getting a copy of that checklist, certainly you can reach out to us for that. It is also important that you address environmental issues, and we'll talk a little bit about what that means. Environmental issues are making sure your workplace is clean, frequently cleaning doorknobs, light switches, elevator buttons, touch points, deep clean if an employee tests positive for COVID-19. Make sure you are on top of those sorts of things. And there are a couple of reasons to do that. You know, one is there's a potential legal risk. OSHA's general duty clause imposes an obligation upon employers to provide basically a place of employment that's free from recognized hazards that are likely to cause death or serious harm to employees. So it's unclear a little bit at this point how this will play out, but you know, bear in mind a violation of that obligation can prompt citations and hefty fines. And OSHA does impose an obligation upon an employer to take reasonable steps to minimize the risk of employee exposure to COVID-19 as relating to work. So you want to make sure that you are doing what you can to keep your workplace sanitized. Other potential risks are, in theory, if an employee develops COVID-19 by exposure in the workplace, it could be considered a workers' compensation claim. Questionable whether benefits would stem from that. The general rule in Ohio is that most disease process claims are not compensable as it doesn't arise out of the employment. But we have seen cases from the prior outbreak, H1N1 from Minnesota, where the employer sent an employee to travel into an infected area, and the court ruled that that was a compensable event. So something that we need to keep our eye on. But the other reason it's important is just to keep your company running as smooth as possible. You certainly want to minimize the risk of exposure, to minimize absences, minimize panic, and generally keep your business running. Employers should keep employees informed about infection control practices at the workplace, and you can require your employees to adopt those infection control practices in your workplace. So make sure that they are educated, keep posters up, inform employees about the importance of hand washing, coughing and sneezing etiquette, proper tissue usage and disposal. Of course, you don't want to implicate the ADA, but you want to just make sure you're educating employees on these infection control practices. And on your part, you should be doing things like making sure that your workplace is well stocked with soap, with hand sanitizer to the extent that you can still find it, but good old soap and water works fine, disinfectant wipes, and again, put up posters on safe practices. Those kinds of things are important. You should also be thinking about business continuity plans. You should be prepared to change your business practices if it's needed to maintain critical operations. So you want to look at things like identifying alternate suppliers, prioritizing customer needs, consider digital meetings if those become necessary, temporarily suspending some operations, and we'll talk a little bit more about that. There are also many employee-related business continuity issues that you should be thinking about. Perhaps you want to develop short-term succession plans for executives. What if some of your key executives come down with COVID-19 or have to be in quarantine? You should think about cross-training critical employee functions to the extent that you can. Maybe you think about things like staggering schedules to minimize close proximity, and the CDC defines close proximity as being within 6 feet of folks. So maybe you stagger schedules, maybe you try to reorganize the layout of your workplace, consider remote work, which we'll talk about a little bit more. Consider if you can go to digital meetings for some of your meetings. Planning also really begins even from the recruiting and hiring process. There are a lot of concerns that you need to keep in mind with that. First of all, consider implementing remote interview techniques, at least for a time, because number one, you really have no real knowledge of a candidate's travels or potential exposure by family members. You can't ask applicants about their health issues because that would be an ADA violation, so you need to be careful about that. And you may have employees who are fearful about participating in interviewing candidates because of concerns about the spread of coronavirus. Also, within the recruiting and hiring issue, you want to make sure that you are considering the fact that you may have increased discrimination risks. There are rising concerns about either bias or perceived bias about candidates whose national origin is from a high-risk area. So you want to remind everybody about your anti-discrimination policies and requirements, especially those who are involved in the interview process. And best practices may include considering implementing more objective criteria, or maybe adding a layer of review with regard to whether a candidate is given a thumbs up or thumbs down. Post-offer, you have a little more latitude in terms of asking questions about where folks have traveled or whether they may be exhibiting certain symptoms or even giving medical exams or making inquiries. Under the ADA, as long as all entering employees in the same job category are asked to submit to that exam or provide the same information, then it is permissible under the ADA. So make sure that that is consistent, and certainly you should not refuse to hire somebody because of information that may come up in those medical exams or inquiries as it relates to COVID-19, but you certainly could delay their start to the end of an incubation period or a negative test result if that's appropriate. I want to talk a little bit about visitors, and I'm actually seeing more discussion about how it may be appropriate to limit or restrict visitors to your workplace. You certainly have more latitude than with employees because you're not making decisions about their terms and conditions of employment. You're making decisions about their access to your site and your employees. So if you are not an establishment, a restaurant, or establishment that could be considered to be a public accommodation, you have even more latitude. I do see a number of our clients are asking questions about recent travel. They're asking questions about whether visitors have tested positive for COVID-19 or have exhibited any flu-like symptoms. Other businesses are considering restricting non-essential visitors, like they're restricting non-essential travel. Bottom line is you want to be, again, objective and reasonable about your approach. You need to run your operations, but you don't want to incite panic. Be cautious, however, if you are a place of public accommodation, because you certainly don't want any ADA or discrimination issues arising if you deny, go back for a moment, only one group, for instance. If you're denying access to your establishment, if folks seem to be from Italy or Japan or China, that would certainly be improper. If you have objective screening criteria, there may be more leeway. But just, again, you need to be cautious. You need to make sure you're implementing these restrictions or cautions in a very consistent manner. One thing that you will almost certainly be dealing with is fears that an employee may have. Fears about becoming exposed to COVID-19 as a result of their employment. I've had employers ask, what about employees who don't want to travel to a conference that they're supposed to go to? What if they don't want to come to work because they are afraid of becoming exposed? Well, right now what OSHA says is that employees may refuse to work if they believe they're in an imminent danger, but as of this moment, OSHA is saying that most work conditions in the U.S. don't meet the elements required for an employee to refuse to work. Now, this is likely to become something of a sliding scale. For instance, if you're requiring an employee to travel to Wuhan, China, that probably is, they may be justified in saying that you're putting them in imminent danger. Requiring a healthcare employee to work without adequate protective gear would be probably a violation of this. So you need to be, look at this as a sliding scale, look at whether there becomes a widespread outbreak in your area, look at whether there's exposure in your workplace, and how do you evaluate and handle based upon that. Speaking of travel, let's touch on that a little bit. Restricted travel for business-related purposes, you as an employer may restrict business travel. The CDC is certainly advising and has been for a bit that employers do restrict all non-essential travel to areas with a warning level 3. Right now that's Italy, China, South Korea, and Iran. And the CDC advises to exercise caution with regard to travel to level 2 areas, and that right now is Japan. A lot of companies are either prohibiting or restricting non-essential travel even within the U.S., so it is a matter of business judgment and discretion. You really need to balance the needs of the matter, the risks in the area, the nature of the encounter, and whether you have other options available. Is it a national sales conference, or is it something that could be more reasonably managed by a video conference? With regard to personal travel, employers cannot prevent employees from traveling to affected areas for personal reasons. However, it is thought that employers could deny the time off or deny paid time off if the denial is based upon the designation, the business cost of a resulting quarantine that might be necessitated upon the employee's return, or other legitimate business-driven reasons, not the employee's national origin. But also remain aware of obligations under leave laws to allow employees leave to care for family members who are ill, and those family members may be in those infected areas. And you also have to remember your obligations to avoid national origin discrimination. So termination or denial of time off should be given great thought. For these reasons, it could create legal risk, certainly decreased employee morale, and negative publicity. So some better options might be that if you have a reasonable belief that the employee has traveled to a high-risk area, you certainly may ask the employee not to return home for that incubation period, and the CDC is consistently suggesting that that is a 14-day period. Now, of course, you want to consult legal counsel, because there are various leave and wage and hour laws at the state and local levels that could impact your obligations in this regard, how you designate the leave, and what you may do in terms of compensation for the leave. If an employee returns from travel during the COVID-19 outbreak, you may ask questions about exposure to COVID-19 during the employee's trip. You do not have to wait until an employee develops symptoms, and it doesn't matter if the travel was personal in nature. You can ask these questions. They are not considered to be a disability-related inquiry, and therefore are not prohibited under the ADA.
So speaking of travel, another thing you may want to look at is your business travel accident insurance policy. You may want to look at it for a number of different things, just to see generally what is the coverage, what does it cover, what does it not cover. So for instance, a lot of policies will cover evacuation services. That may be for employees on, in impacted areas or countries. It may even include evacuation from a domestic area that is impacted. And then global medical services. So if you have an employee that is traveling globally and outside the United States and needs to have medical services provided, most business travel accident insurance coverage will cover those medical costs essentially. And then the other thing to look is oftentimes business travel accident insurance will cover both personal and business travel. And so get to know your business travel accident insurance, get to know, what it covers, what it doesn't cover, so that you can advise your employees, well.
Well, let's bring it back home, away from travel, and talk about telework as an infection control strategy. You certainly may encourage employees to telework as part of your infection control strategy. A lot of companies are doing it, including big ones like Amazon and Twitter. There are some cautions. If you permit telework, it could demonstrate that telecommuting is an accommodation that permits the employees to perform the essential functions of the job if the employee makes that request later as part of an ADA accommodation request. So be cautious about it. Certainly, if you're going to implement the strategy, you want to put parameters around it. You want to clearly communicate to employees that this is part of a unique situation limited to the COVID-19 outbreak. And whether it's right for you really depends upon the nature of your organization and what's going on in your geographic territory at the time. If you're a manufacturing operation, there's going to be very limited number of roles that you can manage in terms of telecommuting, but many companies can do broad-based telecommuting approaches. You should make the decision not based upon fear, not to incite panic, but on objective evidence. And consider also that it may be no small task to reacclimate workers to an office central operation once this is over. Many employees will enjoy that. So some considerations that you want to make: do you want to encourage this, or does there come a point where you require telework for those employees who can perform their roles at home? you do need to look through your workforce, determine critical roles, determine whether those employees can operate remotely, and start to look if additional technical support is necessary. Do you need to acquire more laptops? Do you need to establish additional privacy protocols? Will employees need printers or extra chargers or office supplies at home, and how can you manage that? If you're going to implement this or have this as a backup strategy in the event of an outbreak, then you need to encourage employees to prepare for the possibility of an immediate instruction to work from home. You may make that decision in the middle of the night, and you want those employees to be ready to do that. So have them pack up supplies at the end of the day, including not only their devices, but binders and documents and other physical materials that they may need. You might want to consider having IT help you digitize physical materials in an effort to make remote work easier. And think about setting some expectations regarding availability. Will employees need to be available during all work hours, or will meetings be scheduled in advance? You could expect that you may see a dip in productivity, but you need to look at the longer term picture. And certainly some amount of decreased productivity through telework may be much, much better than the alternative, which could be an entire shutdown and massive loss of business time. If a non-exempt employee will be working from home, you need to think through your timekeeping requirements and instructions to employees so that you can properly track their time and manage any overtime. And you need to figure out whether there will be exemptions for essential personnel who must be physically present. You may get requests for accommodations from employees who say, I want to be able to work from home as an accommodation under the ADA. Employees with disabilities that put them at high risk for complications of COVID-19 might have a reasonable accommodation of working from home to reduce their chances of infection during a panic. So if an employee comes to you with that request, you need to start that interactive dialogue with the employee to determine if the accommodation is proper, to determine if it will allow them to perform the essential functions of their job, and certainly to discuss expectations with regard to the duration of the work-at-home accommodation. One thing that's been coming up a lot is what kind of questions can employers ask about an employee's illness. The EEOC has not issued a new guidance yet on COVID-19, but it has referenced its 2009 pandemic guidance that was issued in response to the H1N1 outbreak. CDC and WHO, again, are not currently labeling COVID-19 as a pandemic, but the EEOC also says that there's nothing in the ADA that interferes with or prevents employers from following the CDC's guidance for businesses and employers. Further, the EEOC's pandemic guidance states that even before a pandemic, questions about symptoms of a cold or seasonal flu are not likely to elicit information about a disability and therefore are not considered to be a disability-related inquiry. On the other hand, if you're asking questions about whether a person has a compromised immune system or medical issues that may make COVID-19 particularly risky for them, that would be a disability-related inquiry. You need to stay away from those sorts of things. What about required testing to the extent that test kits are available? Well, employers, a medical exam under the ADA is a procedure or test that seeks information about an individual's physical or mental impairment or health, and a COVID-19 test would certainly fall within that definition. So during an employment, the ADA prohibits medical exams unless they are job-related and consistent with business necessity. Generally, an examination meets that standard only where the employee's ability to perform essential job functions would be impaired by the medical condition, or, which is more pertinent here, where an employee may pose a direct threat to himself or others because of the medical condition. So this is going to be a little bit of a fluid situation. If you have a significant outbreak in your area. I'm sorry, we're hearing some feedback perhaps on the other lines. Thank you. So again, it may be fluid depending upon what happens in your area. Again, if there is good cause to believe that the employee may pose a direct threat, then it may be something that you can do. Again, I would advise consulting with legal counsel before doing that. Employee absences. Certainly unexpected absences in this environment are going to trigger concern. You know, a couple of weeks ago, you wouldn't have thought anything about somebody being out for a couple of days or somebody having, you know, the sniffles. Now, if the employee has any respiratory issues and is absent for a few days, there's going to be a legitimate cause for concern. You know, did the employee have COVID-19? Did she expose your other employees? And you can and should ask why he or she has been absent from work. Asking why an individual did not report for work is not a disability-related inquiry. It is permissible. Now, what about an employee comes to work or during the day displays symptoms that are consistent with COVID-19 symptoms? You are advised by the CDC to separate that employee from other workers and send them home. Sending them home and instructing them to stay at home is not a disability-related action. You can and should and are advised by the CDC to do exactly that, and the EEOC. What else do you need to do if you have an employee who presumptively has COVID-19? Well, you have an obligation then to inform fellow employees that they have potentially been exposed to COVID-19 in the workplace. What you should not do is disclose the identity of the individual. Now, as a practical matter, the employees may figure it out. Maybe there are only 3 people in that particular cubicle and all of a sudden somebody is not there. It's going to be pretty easy to figure out, but you should not be the one disclosing that, or else you could violate confidentiality requirements, federal, state, and local privacy laws, so be cautious about that.
And speaking of privacy laws, there's also HIPAA to be concerned with. And so, you know, just a reminder, group health plans are covered entities under HIPAA. And HIPAA, of course, restricts the use and disclosure of protected health information. And so it's important to remember that employers cannot get coronavirus status information from their group health plans. And so, you know, making sure that we don't use the group health plan as a shortcut to obtaining information about employees and their status under coronavirus. And then also, but however, you know, even though there are privacy concerns under HIPAA, there are exceptions to the general rule of not being able to provide, use or disclose protected health information. Some of those include disclosures to public health authorities, and that can include state and local, in addition to federal public health authorities. Also, disclosure to family, friends, and others involved in the individual's care. Notification of those individuals is certainly permissible. A permissible exception to the disclosure rules under HIPAA. And then there's also an exception for disclosure to prevent a serious and imminent threat. However, the key here is that your HIPAA privacy officer is really the one that should be making the facts and circumstances determination as to whether these exceptions apply, because of course there are specific requirements of each one of these exceptions. And so prior to disclosing information, PHI, from the group health plan for one of these exceptions or another purpose, certainly check with your HIPAA privacy officer. They should be making that determination before you disclose any information from the group health plan. And even if there is an approved your reason or exception under HIPAA, it's important to remember that the minimum necessary rule still applies, and you should only be providing the minimum necessary information in order to accomplish whatever the objective is in providing that information. So that's certainly something to keep in mind whenever you're talking about HIPAA and PHI.
Thanks, Stephen. If an employee does test positive for COVID-19 or you send them home and there's reason to believe they have COVID-19, what is recommended is that you send home all employees who've worked closely with that employee for the past 14 days, or send them home for 14 days to ensure that the infection does not spread. What is working closely with the employee? CDC says that is a 6-foot zone. So that's the social zone people are talking about now, 6 feet. You should consider asking a cleaning company to undertake some deep cleaning of your affected workspaces. Unless somebody tests positive for COVID-19, that's not necessary, just the enhanced precautions that we talked about earlier. And if you do work in a shared office building or area, you should inform building management so that they can also take whatever precautions that they might deem necessary. But again, remember confidentiality. You should not be disclosing the identity of the employee or any other information beyond that, which is minimally necessary. What about employees with potential exposure? Well, employees who have been exposed to individuals outside the workplace with COVID-19 symptoms or with individuals who have tested positive should be treated the same way as you handle exposure in the workplace. So again, 14-day quarantine. We'll talk about payment and compensation obligations in a moment. But the CDC does not recommend testing, symptom monitoring, or any special management of contacts. So for instance, an employee has a spouse who traveled to an affected area, but the spouse does not demonstrate any symptoms. That's a contact. We recommend self-reporting, but not necessarily quarantining at this time. In terms of doctor's notes, currently there's no formal clearance process for employees to return to work from the coronavirus. Employers may request documentation under certain circumstances. Certainly you can be consistent with your policies. Just requiring a doctor's note certifying their fitness for duty is not disability related. Inquiries are permitted under the ADA either because they would not be disability related, like the seasonal flu, or they would be justified under the ADA standards for disability related inquiries under the direct threat prong in the case of a more severe outbreak. Now, what about FMLA leave? This is a good question. You should, on the one hand, you shouldn't be playing doctor. You want to encourage people to take leave if they are not feeling well, so that you can limit exposure. From a technical standpoint, FMLA leave probably doesn't apply in a lot of cases because FMLA leave requires a serious health condition. That's inpatient care or continuing care by a healthcare provider. And in this circumstance, it would require an illness or capacity that results in the inability to work for more than 3 consecutive calendar days with either 2 or more in-person visits to a healthcare provider within 30 days, or 1 in-person visit with a regimen of continuing treatment like prescription medication, physical therapy, et cetera. So most people, they are telling us, who come down with COVID-19 will be told to treat it like the flu. So they may or may not go to the doctor. If they do, they may only go 1 time. And technically speaking, it may not fall within FMLA in many circumstances. However, you can provide leave outside of the FMLA, and again, consistent with Stephen's advice regarding how that impacts your benefits policies. And also bear in mind that there are a lot of states and local municipalities that do have specific leave and paid leave requirements. So again, consult with legal counsel before you're making decisions on exactly what that leave looks like. Employees may not use FMLA leave to stay home and avoid potential exposure to COVID-19 at work. Again, you may have some ADA accommodation circumstances if somebody's at high risk, but not an FMLA leave. Again, you have to have that serious health condition for the FMLA leave to trigger. With regard to PTO, federal law does not govern the terms or use of PTO, so you should be following your policies. Primary consideration, again, will be whether you have regulation at the state or local level that require paid or unpaid leave policies. From a technical standpoint, if you have a policy that requires people to use their PTO for vacation or illness, you can follow that policy, but think through the business practicalities of that. People may be reluctant to use up their vacation days, their PTO days, when they don't need to, so they may come to work when maybe they shouldn't because they're fearful of using up that time off. So again, you may want to think about a specially created leave opportunity for coronavirus situation.
And another thing to consider is, a lot of employers may want to encourage sick employees or employees that aren't feeling well not to come to work. And one way to encourage that or incentivize that would be to change the eligibility or waiving the elimination period under their short-term disability plan. However, if you are considering that, remember that if it is a plan governed by ERISA, changes in the eligibility or waiving of the elimination period requires a plan amendment and a disclosure, an SPD or an SMM or something along those lines. In addition to that, also you need to coordinate with either your insurer if it's a fully insured product or your third-party administrator if it's self-insured in order to make sure number one, that they will approve it if it's an insurer. Number two, that they will administer it if it's a third-party administrator. So something else to consider if you're considering changes to your short-term disability plan in order to encourage that employee to stay home when they start to get symptoms that may or may not be coronavirus going forward.
Unemployment compensation, workers are generally entitled to unemployment insurance if they're furloughed when a business temporarily shuts down and all other employment requirements are met. So you may be, from a compensation perspective, if you get to a point where some or all individuals are laid off for a period of time, unemployment will likely kick in for them. We'll talk a bit more in a minute about what kind of notification requirements that you may have to the employees, but depending upon the size and length of the temporary shutdown, your jurisdiction may require notification to the state or local government regarding the applicable unemployment department as a mass separation. So again, consult with legal counsel on that issue.
And in addition to the health and welfare plans, as you're looking at coronavirus and its impact on your business, another consideration is 401k plans. So for instance, hardship distributions. Most plans use the IRS's safe harbor distribution, hardship distribution parameters. And while medical expenses may be included either for the employee or for dependent of the employee, typically the safe harbor definition would not include sort of your lost wages or any other expenses of a furlough or some sort of quarantine or anything like that. And so, you want to, make sure you're aware of that. And, plan loans would be sort of a secondary option if hardship distributions are not an option for an employee, or if the hardship distributions can't cover costs like the lost wages and other expenses. So plan loans is something else to consider. And of course, recently the IRS has come out with guidance on other natural disasters, hurricanes and earthquakes and wildfires and things like that. So it's certainly a possibility that with the ever increasing awareness of the impact of coronavirus on the United States, we may have some additional loosening of the requirements by the IRS for hardship distributions and plan loans. And something else to consider, of course, and I don't have to tell you this, but there's a lot of market volatility with regard to the coronavirus and other things like that. And so, obviously investment performance is going to be negatively impacted by that. And certainly investment option changes. You're going to have individuals that may, get some cold feet and try to sell. And so you may want to consider maybe some employee communications around that, telling people to, stay the course and sort of ride out the waves and don't get too rash and sell when their 401k plan account is down as much as it may be recently. And then another thing to consider, both for health and welfare plans and 401k plans, any of your benefit plans, are force majeure contracts, and whether or not your vendors may be forced to or may need to use that, a lot of contracts, a lot of service agreements, may have that provision, and depending on whether and to what extent this may get worse, it's important for you to understand the terms of your contract and make sure you understand whether that provision is something that your vendors may be able to implement. And of course, that would be bad if your 401k plan is no longer being administered, or worse, your health plan, in a time of need, if your third-party administrator or your insurer, tries to invoke that force majeure clause. And then something else from a medical plan standpoint that a lot of insurers will do, and you may want to consider as a self-insured plan, is loosening plan requirements during a pandemic. So things like, maybe decreasing the waiting periods, or allowing a larger supply of prescription drugs during the pandemic, things like that, or even waiving prior authorizations or other plan limitations in affected areas. I think it's important to have a conversation with your vendors about things like the force majeure clause and to what extent they may, invoke that, and then to your medical plan provider about, have that conversation early so that you understand, you're on the same page as your vendor as to, if this thing gets really bad, what types of actions can you take to help our employees, and make sure you're on the same page so they understand, so that in the heat of in the midst of a pandemic, you guys, the two parties have already talked about it, discussed it, and you already have a plan in place for how you're going to deal with, the seriousness of a pandemic.
Let's talk about a few wage and hour issues that you should be considering. With regard to your non-exempt employees, certainly you are not required to pay non-exempt employees for non-working time. So if, for instance, business operations are temporarily closed because of an outbreak, or if they need to take time off because of exposure. Federal law does require, of course, you to pay minimum wage and overtime for hours worked, but generally if they're not working, they are not required to be paid. Now, again, as I mentioned earlier, from a practical perspective, you may want to consider whether you want to provide some payment or some policy of payment for a period of time, so that you make sure that employees feel comfortable to not show up to work when they might be at risk for exposing other employees and creating a larger scale issue. That's going to be a business consideration that you need to sort out given your particular operations, your ability to absorb that, your geographic area, and certainly something you should do in consultation with counsel. With regard to exempt employees, typically employers must pay those employees their full salary for non-working time if they are working any portion of that week. If you are in a shutdown situation, a temporary closure, you're generally required to pay exempt employees for non-working time if the business operations are closed because of an outbreak of COVID-19 for less than 1 full week. So less than 1 full week, unless there are some exceptions that apply, you need to pay the full salary. If you're closed more than 1 full week, you're not required to continue paying salary to your exempt employees. Also bear in mind that if you do face a shutdown situation, you may have some WARN Act implications. So if you are covered by the WARN Act, if you have 100 and more employees and you are required to have a temporary shutdown or facility shutdown, you are required to, under the WARN Act, provide 60 days advance notice or as much notice as reasonably possible if you meet the triggering requirements. There are some exceptions when layoffs occur due to unforeseeable business circumstances. Certainly, we cannot tell whether in future litigation this would be considered to be an unforeseeable business circumstance. So best advice is if you are going to have a temporary shutdown or site shutdown, that you provide as much notice as practical to the employees, and also make sure a lot of states and municipalities have many WARN Act laws, so you need to make sure that you are complying with those acts as well. With regard to other discrimination issues to consider, a couple of things to think about. Again, you need to be consistent. You need to be treating your entire workforce under the same rules. You cannot request or require employees stay at home if their national origin is a country with a level 3 travel health notice. And certainly, again, re-emphasize your anti-discrimination issues to your managers, to your HR folks. Make sure everybody is aware that this is a heightened issue at this particular time. Again, some consideration that employees who contract COVID-19 as a result of exposure may have a workers' compensation claim. Again, another thing that will be playing out in the days and months to come. And one other reminder is that there are insurance policies and expenses that may be at issue, and you should be talking with your insurance agents now to review your policies, see what expenses might be caused by COVID-19 might be covered. You may have business interruption insurance, liability insurance. Obviously, this is a case-by-case analysis, but we would be remiss if we did not urge you to consult with your agent so that you can determine what coverage and options you may have. And at this juncture, I'm going to turn it over to John to talk about some labor issues to consider.
Thank you. Yeah, if you have a business partner at your place of work, otherwise known as a labor organization, some of these issues will have to be at least discussed with the union before you can make the adjustments and changes that you think are necessary. As the first slide indicates, employers generally have a duty to bargain over any mandatory subject to bargaining, which would be wages, hours, and other terms and conditions of employment. And obviously leaves and compensation and benefits all would fall into that category. It's important to note, though, that what your duty is will be very collective bargaining agreement specific. Most CBAs have a management rights clause. Some are short, some are long, some are narrow, some are broad. But the first place to look in terms of what you can do without bargaining and what you can only do with bargaining is going to be your management rights provisions. There may be other provisions regarding scheduling of shifts, determining hours of work and that type of thing, but the management rights provision is going to be the critical language in deciding to what extent, if any, you have a duty to get the union's agreement before you make any changes. I should also add that even if the changes that you want to make are employee-friendly and more beneficial than what exists now, even if it's an improvement in benefits, there's still a duty to bargain. And the union, believe it or not, will say that you have to bargain with us first, even if you want to give us some benefits we didn't previously have. From a broader perspective, though, it's important to note that from 2009 through 2016, there was almost nothing in a management rights clause that an employer could point to that the labor board would say gives you the right as management to take unilateral action. Beginning in 2017, this board is very employer-friendly and interprets management rights clauses far more broadly and far more expansively than the previous board. So if you're careful about how to do this, then the risk of an unfair labor practice charge, or at least one that's meritorious, is fairly small. You do, if you have a duty to bargain, if there is a duty to bargain, you have to give the union adequate notice. And there's no rule on how much notice you have to give, but in circumstances like this, I think a compressed advance notice period is likely to be found permissible. But let me say one other thing about management rights clauses. Whether or not you have a duty to bargain, before you make any changes, you should sit down with the union and talk to the union about the changes. You can even ask for their input. You could brainstorm with them and see what they have to say. Now, but there's a line between bargaining and talking. And so I always recommend you talk to the union, but not necessarily bargain, because if you treat it as bargaining and they don't agree, then you're at impasse. And so I prefer to just say, we want your input. We're going to take that into consideration. We want to talk to you, but we do not believe we have a duty to bargain, meaning we don't have a duty to reach an agreement before we make some of these changes. Some of the things that you might want to consider bargaining over are things like having employees tested for COVID-19 and whether you'll pay for the testing, and whether you'll pay for the time taken for the testing if you require that. You may want to talk about longer shifts or different shifts that are more accommodating to this threat. You may want to talk about relaxation of cross classification work. Many contracts are very strict in terms of only certain employees can perform certain kinds of work, and supervisors and managers are not typically allowed to perform bargaining unit work except for training purposes or in an emergency. Well, you could argue that this is an emergency, but in any event, one of the things that you would probably want is greater flexibility in terms of who is permitted to perform which work. You may want to talk about relaxation of attendance policies and leave policies. You may want to talk about salary continuation or some sort of reduced rate for quarantined employees. But overall, the main thing you want to do is get some alignment with the union about what you're going to do to deal with this as partners as opposed to as adversaries. One thing to keep in mind, though, is that the National Labor Relations Act applies to even non-union employees. And if employees are talking about the employer's response to the COVID threat, and saying, I think the company should do this, or I don't think they should have done that. You need to understand that union or no union, those employees are likely engaged in what's called concerted protected activity, because an employer's response to this threat is obviously a term or condition of employment that affects health and safety. So keep in mind that while you may have to bargain with the union, any employee can discuss with you or can discuss among themselves their reaction and their assessment to how the company is responding to this. In my view, the biggest threat is not an unfair labor practice, but for you to make a change and for the union to say you violated the collective bargaining agreement and therefore file a grievance and try to arbitrate it. Which leads me really to one of my final points, and that is whatever you agree to with the union, you need to memorialize that in a memorandum of understanding so that unfair labor practices and grievances are likely to hit a wall if you have something in writing that confirms what it is that you and the union agreed to. The likelihood of a strike in a situation like this is extremely small. And that's primarily because every union, either in their bylaws and or their constitution, requires that there be a strike vote taken. And the likelihood of a union authorizing a strike in light of this circumstance is quite small. What's more likely is whether the employees engage in sick-outs, which are very common in transportation industry as well as in law enforcement, and that's where just a lot of people say, I'm sick. Whether or not that will happen or is more likely to happen depends upon whether or not you're going to pay the employees when they call in sick, and because if they're not going to get paid, they're less likely to do that. That's the only thing that I wanted to comment on in traditional labor. Let me just mention one of the things, though, about working at home as an accommodation. And that is this: if you allow employees to work at home as an accommodation, I encourage you to monitor how that is working out, because if allowing employees to work from home is not working out and they are unable to perform the essential functions of the job, it is not something that you therefore need to continue to do, because it has been found to be unreasonable. And so keep that in mind, that whether you do that, you're not locked into it indefinitely, especially if it turns out it's simply a job that cannot be fully and adequately performed at home. And that's all I have to say about that.
Thanks, John. Just a couple of notes before we get to the question and answer point. We do have an immigration team within our labor and employment group, and they can assist you with any issues and questions that you may have on the immigration front. But just a couple of reminders of things to keep in mind is that as a company, if you have international operations, you should review where expats are located on assignment, consider whether they should be moved back to home countries. Review visa expiration dates, determine if those visas will be able to be timely renewed in light of limited consulate services and or limited travel policies. Review international assignments scheduled for the upcoming months and determine if, in fact, they'll be able to proceed. Consider H-1B required wage compliance if you are benching employees due to quarantining or shutdowns. Consider H-1B required wage compliance if H-1B workers have requested time off. So again, those and other immigration issues are something that can be handled by other members of our team if you have a need for those. So a couple of notes: that we've reached the end of our prepared presentation. I know we've had a lot of questions come in about the written materials. We are going to post them to our website, so they will be available to you. I think we've already had some requests for the checklist, and we'll be getting those out to those who would like to have that. I would also mention, for those of you who need to drop off, that we have prepared a product that provides for a 1-hour consultation on COVID-19 issues for a flat fee. And if you have, if you think that is something that you're interested in, contact us. We will make sure that we get you to the right specialist or specialists, depending upon the nature of your concerns and inquiries. So at this time, we are going to go until we can talk until about 1:30, and we'll field some questions that have come up and that you have provided us. If by chance we don't get to all of the questions at the end of our time together, we will certainly follow up with you and answer those by email. So with that, I think, Stephen, you've been compiling some of the questions here, and Brian in our Atlanta office.
Yep. So I think some of these have been answered later on in the presentation, but I'll go ahead and ask them anyways. Can employees be required to report personal travel?
You can certainly request that the employees report personal travel. If they refuse to do so, they could claim that that is, that's private information. However, you could consider whether you want to go ahead and put them on some quarantine basis for 14 days, depending upon the level of risk that you reasonably assess.
Great. Another question. What, if anything, are employers doing to support employees who may have exhausted sick time and would have to be on leave without pay?
Yeah, I think that's one of the things we touched on in the presentation, that a lot of employers are considering whether they want to adopt some kind of supplemental leave policies for this period of time, whether it is for unpaid leave or for some type of paid leave, for those practical considerations of making sure people feel comfortable taking the time off when they may be ill or exposed, and limit the exposure to the rest of your workforce. If you do decide to implement a policy like that, you really need to make sure it is in writing, make sure that you're placing parameters around it, identify that it is related solely to the COVID-19 outbreak and your response to that, so that this is not used as some sort of precedent in the future. And I would just ask, John, do you any other special traditional labor union considerations in that regard?
No.
Great.
Another question. If the WHO, the World Health Organization, declares a pandemic, what is an employer's obligation, or does that vary?
That's one of the reasons why it's important to have a team and a point person, so that they can monitor those declarations and any further instructions. I suspect that if we see a pandemic declaration, we will also see further guidance from the CDC that would correspond with that. You may have local guidance from states or municipalities about what must occur in your area. There may be government-ordered shutdowns, potentially. I will say that in the event of a pandemic, the EEOC's pandemic guidance does actually allow you as an employer to check employees' body temperatures to monitor for risk of fever. Now, not everyone who comes down with COVID-19 exhibits a fever, but that is one other thing that you consider in the event that there is a declaration of a pandemic.
Great. So this next question is actually for me, Debbie, so I'll let you take a breather here. What site can we monitor to see if the IRS is waiving or not enforcing the employee ineligibility to HSA contributions? So unfortunately, the IRS has a number of different ways in which they communicate. I would say the best way to stay on top of any IRS guidance is to get on their mailing list. They have an email list where they send out daily emails updating on sort of what's going on with the IRS. I would recommend getting on one of those and getting on that email list, getting those daily emails. Certainly stay in contact with your employee benefits attorneys and we'll certainly keep you informed on what's going on with that. But like I said, the IRS email string is probably the best, email list is probably the best way to stay on top of that. Would this be considered a recordable OSHA event?
If there is a positive report of COVID-19 in your workplace, the general thought is that this would be considered an OSHA reportable event, and you should report it.
Great. What can an employer ask employees about their health status that may require quarantine?
I think we've covered a lot of this in the materials. Again, you cannot ask underlying medical conditions, but you can ask about symptoms. If you can ask about absences, why an employee was out of work, what was the reason for their absence. You can ask if they are experiencing cold or flu-like symptoms. You can ask about their travel, and certainly if you observe symptoms that seem consistent with the coronavirus, even if they have not reported that they have been exposed or that they believe they may have it, you as an employer can step in proactively and have them remain at home for a 14-day period.
Great. Should we track the responses to questions asked of visitors to their locations?
I'm not sure that it would be a great idea to track the responses of visitors unless you get a report of somebody who visits and says that they have tested positive for COVID-19. I don't think, you may not get any reporting like that. If so, I would not track that by identity, but it might be important to know, again, to inform the building management, for instance, that someone has come into the building that has tested positive for COVID-19.
Right. Can our employees refuse to answer health questionnaires when they are visitors to customer facilities due to privacy reasons?
I think that the employees, I've not seen any guidance specifically on this, but I would say that employees could certainly refuse to answer, but that vendor or customer could certainly then refuse to allow them to enter the facility.
What about individuals interested in returning to home country for immigration visa renewal?
That would fall within an immigration question, and to the individual who asked that, we will make sure to have one of our immigration specialists reach out to you.
What is the guidance in asking employees what their personal travel plans are?
Once again, you certainly can ask your employees where they are planning to travel to, or when they return, where they have traveled. And again, I think, as I mentioned earlier, if they fail to disclose and you have a reasonable belief that they've been to a level 3 or a level 2 area or another heavily impacted area, it would be within your discretion to require them to remain at home for a period of time. Again, I would just urge that you apply that standard consistently, not just with folks who travel, who have a certain national origin, for instance. So just make sure you are consistent and thoughtful in how you implement those policies.
Great, thanks. I have an employee at a non-work-related conference. Can I ask them to self-quarantine and work from home for 14 days?
Would need a little bit more information about this one to be able to provide a good response. So again, we can reach out by email and try to set up a contact so we can get some additional information to help you out.
Can we ask where they're going or what they're doing prior to approving time off?
Yes, I think this is addressed by one of the slides we had earlier. You are permitted to make those inquiries.
If an employer cannot ask about underlying conditions, but travel to Japan is not recommended for such people, what can an employer do?
I'm going to assume that this question relates to personal travel. And once again, upon the employee's return, an option would be to have the employee stay at home for the 14-day period for quarantine. Again, in all of these times when you're requesting an employee to remain home if they're not ill, that's when you really want to think about what your policies are going to be. Can you have them work from home, telework, and that way there can be salary continuation? Do you want to think about other types of pay continuation? So those are the kinds of things as part of this, setting your pandemic plan. These are the sorts of things that you need to be thinking through and developing that.
Absolutely. What liability does the company face if an employee contracts the virus while at work? And I think you touched on this during the presentation.
And again, just to briefly on that, it may be a workers' comp event. There may be, if one employee contracts the virus and you don't take enough precautionary steps to make sure that you inform employees, that you make sure that you are cleaning, then that's going to subject you to an increased risk. So again, that's why some of those safety precautions and educational precautions and information that you distribute is very important.
Great. What about age discrimination issues, given the stated increased risk for people over age 60?
That's a really good question, and again, and something that we haven't really noodled over here, but there is a potential for discrimination or the perception of discrimination if you're treating those folks differently. Now that, again, if someone comes forward to you and says, hey, I'm over 60, I have these underlying health issues, I'd like to work from home as an accommodation because of the increased risk, and you determine that it's appropriate for them to be out, then that's something they've come forward to and requested. If you're singling folks out simply because of their age and treating them differently than you treat other employees in terms of your quarantine and such, then that's when that becomes a problem. So again, consistency is key. Great.
The next question actually is for you, John, dealing with collective bargaining negotiations and what's required if part of the bargaining committees is required to travel. Brian, do you want to read that to him?
Yeah, I see it.
Okay.
Yeah. What happens if we're planning to be in collective bargaining negotiations from March 18 to 31, which requires part of the bargaining committee to travel? Are we able to approach the union with contingent plan recommendations in the event the dates need to be deferred, even if that pushes the bargaining dates outside of the expiration of the collective bargaining agreement? And the answer to that is yes, you can certainly approach the union with that, although part of the agreement or understanding, I think, would have to be you probably want to agree to extend the expiration date of the contract for another, pick a number, 30, 60, or 90 days to accommodate the need to postpone or delay the in-person bargaining.
Great, thanks, John. And we've actually got an update. We're going to be sending out a copy of the presentation to everyone that attended the presentation. So we'll be doing that probably later today. If an employee desires to wear a protective mask in a customer-facing role, the manager does not want to permit that for fear of sending a message to customers that the employee is infected. Should the manager deny this?
Right now, the guidance, and I believe the CDC has issued some guidance on this, in customer-facing businesses, there's certainly a legitimate business reason for the employer not to want to either induce panic or create a fear among potential customers. And right now, there is not a requirement for employers to allow that type of accommodation unless you're not talking about a healthcare worker, or you're not talking about somebody who would be a first responder or something like that. So right now, the guidance from the CDC is that you do not have to permit that in the workplace.
Great, thanks. Is it okay to institute a policy of staying out of the office for 14 days if an employee takes a cruise or travels to a level 2+ country?
Yes.
That was easy. Who makes a pandemic declaration? Who? CDC, the governor?
For an official pandemic declaration, it is the CDC and the World Health Organization. We have seen certainly some governors declare states of emergencies, ours among them as of last night, and that can have implications for your business as well. But the official declaration of a pandemic comes from the top, from those organizations.
Gotcha. We are a 24/7 hospitality resident management organization. How should we plan to meet contract requirements for our clients?
Yeah, I think that's another one there are some specific guidances for hospitality industries, and that is, again, another one that we would need some additional information. So we'll follow up directly and see if we can help you out with that one.
Any guidance on stipends employers should provide employees who are wait, just lost it. It's weird. Who are required to work from home? Okay. If a company conference is canceled that other firms pay to attend, any best practices of how a cancellation should be handled? I'm going to take very specific questions now.
Yeah. I'm going to assume that that's a conference that your organization is putting on and then you cancel it. Really, I'm not aware of any employment law issues that would arise under that. It's more how you want to handle that from a business interface standpoint and your customer relationships. But there wouldn't be anything from our specific area that would weigh in on what you need to do in that regard.
Gotcha. OSHA, recordable versus reportable. The question was about recordability. You said it's reportable. Is there a difference?
John, do you want to weigh in on that one?
Yeah. There's no difference. The only thing that I would add is that the employer, I don't think, can assume that just because an employee contracts the virus that it was contracted at work. And the OSHA requirement is that the employer has to have reason to believe that the employee contracted the virus at work, which I guess under some circumstances you could reasonably come to that conclusion. But in light of how little we know about it and where everybody's been, I don't think that any presumption would exist that just because one of your employees contracted the virus, that it was contracted at work and therefore is a recordable incident. And obviously, to the extent you'd prefer not to treat it as a recordable incident because it can involve insurance rates and so forth. And I'm not saying you should avoid it, but just you should only report it or record it if you believe that you have a basis to believe the employee contracted the illness at work.
Gotcha. Thanks, John. You recommended sending employees home if someone in the workplace tests positive. However, we are not allowed to reveal who the person is. So how do we know who they had contact with?
Good question, and this was in my notes, but something I didn't cover, so thank you for bringing this up. When you're sending that employee home, one thing that you should be asking them is, okay, who have you worked in close proximity with during the last couple of weeks? And that close proximity, again, is that 6-foot range. Or, ask them, okay, are there any coworkers that you spend time with socially, go to lunch with? So ask that impacted employee who they believe they've come into contact with. And then as managers, use your best judgment as well. Obviously, if they work in a cubicle with 4 other people and they're working on the same project, you're going to know whether they disclose or not that those 4 people are impacted. So I would begin with those steps to try to identify who you should specifically inform about potential exposure.
Great. In order to screen visitors and contractors in a workplace, can we ask if they have a temperature, dry cough, or have been in potential contact in the past 14 days?
You can either ask those questions or you can make that presumptive, have some policy that you have at the front desk or that you have people that you put out ahead of time that says, we assume if you come here, you do not have these issues. Again, you have more latitude with visitors, but you do want to be sure that if you're adopting those policies, you're applying them across the board in a very consistent manner, and also special considerations if you are a place of public accommodation.
Great. Much of our workforce is placed at customer sites, so we are somewhat reliant on what our customers' pandemic plans will be. Do we have an obligation to treat all employees across our organization the same with respect to telework, or can we, et cetera, or can we treat them differently based on what the customer has put in place?
That's something I would like to have a longer conversation about. Yeah. Sort of the instinct would be you want to be consistent. But if you have some customers that have very detailed plans and others who have nothing at all, then that in and of itself may call for some deviation. It is most important that you deal with the employees who are at customer A the same way, and if customer B has a different policy, that you deal with all employees at customer B consistently as well within that structure.
Yeah. Okay. Maybe one more question. Do we need to complete a hazard assessment to have potentially sick individuals wear medical masks while exiting the building?
Ask that one again?
Do we need to complete a hazard assessment to have potentially sick individuals wear medical masks while exiting the building?
John, any thoughts on that one?
My only thought is, my answer would be no. I don't think there would be a duty to do that. Not without more information than what we have now.
Right. Great. Okay. I think that's about time for today.
Yeah. Thank you all very much for attending. Once again, we have a checklist that's available. Please let us know. We have a very multifunctional team, so any issue that you have in the employment spectrum dealing with COVID-19, certainly happy to assist you. And again, I'll remind you that we do have the product for a 1-hour consultation if you're interested in that. Also, if you're not currently receiving our updates and invitations, We do invite you to go to the Thompson-Hein website and register to receive those. You do so under the Publications tab, and we do issue regular updates on a variety of topics, including the coronavirus. So thank you all very much for your interest. Thank you for attending today's webinar, and enjoy the rest of your day.